24 minutes past the hour now. A federal judge in San Francisco has ruled that thousands of FBI's secretive requests for customer information are unconstitutional. The FBI sends those so-called national security letters to banks and phone companies and other businesses every year demanding customer information. The FBI sends those letters without any judicial review, and the recipients of the letters are banned from making them public. So it's a huge secretive proposition. Now, on Friday of last week, the judge ruled that the government has failed to show the letters and the blanket non-disclosure policy, quote, serve the compelling need of national security, unquote. The judge also ruled that the gag order violates the First Amendment. Fox News senior judicial analyst Judge Andrew Napolitano is with us now. This goes to the fundamentals of something we talk about around here all the time. What of your private information should be available to everyone?
Yes. I mean, after 9/11, the Congress enacted and President Bush signed into law the Patriot Act. And among many other changes to the law, it authorized FBI agents on their own to serve search warrants or subpoenas on custodians of information. So a telephone company, a computer provider, a hospital, a lawyer, a doctor, having someone else's information. They call that search warrant, which goes around the Fourth Amendment, which requires that only judges sign search warrants. They call those search warrants national security letters. So when the FBI comes calling to your or my computer server and says, here's a national security letter, we want Shepard Smith or Andrew Napolitano's records, they also say you can't tell them that we're asking for these records. In fact, you can't tell anyone because the statute makes it a crime for the recipient of these national security letters to tell anybody. That's the part that was ruled unconstitutional by this federal judge in California on Friday, because that runs up against something called the First Amendment, which says Congress shall make no law infringing the freedom of speech. So how could Congress make it a crime for people to talk about the government seizing private information without going to judges first?
This is a process that's underway now that we knew that everybody who was paying close attention or trying to knew after the Patriot Act was enacted would eventually go away. It was a matter of when we all settled down and remembered the Constitution. This has happened. There's much more to come, probably, right?
Well, the Patriot Act had a sunset clause in it after 4 years. That was extended another 4 years. That was extended another 8 years. So we're still into the period of time where the FBI agents have this authority. But parts of it have been declared unconstitutional by 6 different federal judges, and the federal government still uses it because, you see, if the custodian of the records, in this case a computer provider, doesn't squawk or complain, just complies with it, the person whose records are sought doesn't even know that those records are sought. So they're not even in a position to complain about it or challenge it before a judge. It is the rare custodian of records who says, you know what, I think these records are private. I think there's something wrong with this statute, and I shouldn't just hand them over to you. It is that rare custodian of records who will challenge them. This challenge in California had the result where the judge said, can't do this anymore. People have the right to know when their records are being seized, and they have the right to talk about it in public. So the statute is unconstitutional.
It's going to be interesting to see what all has been done without anyone's knowledge.
Over 350,000 of these national security letters have been served since 2011. You think anybody we know has been the subject of it?
I'm dreading it.
Yes.
Thank you, Judge.
Pleasure, Shep.
When it comes down to cracking down on marijuana in states where they have legalized pot use, President Obama has said the federal government has bigger fish to fry.
It does not make sense from a prioritization point of view for us to focus on recreational drug users in a state that has already said that under state law that's legal.
Okay, so now that some states are eyeing ways to block upcoming federal gun control laws, has President Obama set the precedent? Joining us right now, Fox News judicial analyst Judge Andrew Napolitano.
Very clever, precedent.
Try putting that in the teleprompter 12 times.
There you go.
Well, this is interesting. So the president says when it comes to pot, we got bigger fish to fry. When it comes to gun laws, what say you?
Well, there's a very practical reason why the president is going to back off on enforcing federal laws against the recreational use, or any use for that matter, of marijuana in Colorado and Washington. That's because in those states it is now illegal for employees of the state That would be not just administrators and bureaucrats, but police,
Right.
to help the feds enforce federal law. And what most people might be surprised to know is the federal government does not have the person power and resources to enforce all federal laws on its own.
Sure.
It needs the assistance of state and local police as well. They don't have that in Colorado and Washington because marijuana is lawful there. So it might be impractical and be too costly for the feds to enforce it. That's one of the reasons he's backing off. Will he do the same on guns? I don't think so. I think that he and his administration are ideologically wedded to what, in my opinion, is an unconstitutional and absurd view that the government can limit our right to self-defense.
Right.
So, if the federal government limits guns in a state, will it need the assistance of state police to enforce those limitations? Yes, it will.
Sure.
And do the states have the right to refuse to enforce federal law that's against state public policy? Yes, they do.
Sure.
That's where we are on this.
That is where we are. And the reason a number of states are trying to come up with this new gun legislation is because they see Washington, D.C., and they're worried about a gun grab.
Correct. Now, the states, our home state of New Jersey, could not, for example, use the police to frustrate federal law enforcement. But it could say to state and local police, you will not cooperate. That will make federal enforcement of tighter federal gun laws nearly impossible.
All right, Judge Napolitano, we'll find out what they do because, of course, the federal government has bigger fish to fry.
Yes, we all know that.
Right.
Where did Kill Me go?
I don't know. I hope he's getting me some hot coffee. A new health insurance policy is stirring things up at one of America's most famous pharmacies.
CVS Pharmacy is telling its employees to report their weight, their fat, and their glucose levels to the health insurance bosses. And if they don't, it's a $600 fine each year.
Is that legal? Fox News Legal Analyst Judge Napolitano is here. Judge, can we arrest them?
No, you can't. You can't arrest them. And I wish we could arrest Obamacare because that's the impetus for this.
It might turn itself in.
Gosh,
by the way.
I don't expect that it would voluntarily die. But look, CVS has taken a position because the government has put this burden on us. We are now authorized to find out who are the healthiest among us, since it will save us a lot of money, our shareholders a lot of money, our customers a lot of money if we can pay less for health insurance because our employees are healthy. Can they do this? Answer, yes. Now, they can't target women or men or a racial group or a religious group, but because civil rights laws govern them. But the privacy laws permit them to make reasonable inquiry of their employees if the answer to the inquiry will help the business of the employer operate more efficiently.
Well, this is scary because this means that any company could do it. But,
yes.
But where do you draw the line? I mean, first they want to know how much you weigh, what your glucose levels are. Next they're going to want to know, are you a smoker? Next they're going to want to know, do you drink coffee? Did you have a Snickers bar this week?
Well, you know, I don't know how. It's a good question, Steve. I don't know how far it's going to go because this is the brave new world of Obamacare kicking in. And this is either an unintended consequence or an unrevealed consequence when they debated and enacted that 2,700-page monstrosity that we're now saddled.
But let me tell you what CVS says that their motivation for doing this is. A health screening and wellness review so that colleagues know their key health metrics in order to take action to improve their numbers if necessary. This is the wave of the future, which is more personal responsibility and having to stop these things like smoking and eating poorly if it's up to you.
I don't think this is a wave of more personal responsibility. I think this is a wave of more corporate intrusion, because the corporation now has an interest in just how healthy its employees are, because when they're not healthy, the corporation, is going to be paying higher premiums, because of the new heavy regulation of the healthcare industry by Obamacare.
I'm pretty sure you just reprimanded her, but we'll talk about it in the break. It sounded like
no more meatballs from your aunt in South
Fight your
Jersey.
tongue. Fight your tongue, Judge.
Thank you very much.
Judge, thanks.
There's some outrage being expressed over a controversial mandate from one of the nation's largest pharmacies. CVS is just weeks away from requiring their employees to hand over personal health information like their weight, their body mass index, their glucose levels, and more. And those who don't fess up or don't want to be part of this are going to be fined. An annual fine of $600 if you don't turn over this information. CVS says it just wants to help those employees to be as healthy as they can be. Judge Andrew Napolitano joins us now, our senior judicial analyst, who's in great shape these days and would have no problem turning over his data. He's happy to share it with us.
Very kind.
So what do you think?
I think that this is a consequence of the federal government micromanaging health care and forcing employers to provide coverage to all employees, many who otherwise wouldn't qualify for it, and forcing them to provide coverage whether the employees need it or not. So CVS has 200,000 employees. They now have an interest in hiring 200,000 healthy employees. Think about it. If they can save a few dollars a month, that's $1 million a month total, and $12 million a year, et cetera. Their job is to maximize profits for the shareholders and make CVS work as efficiently as possible. So will Obamacare result in larger people with larger body mass and higher glucose levels not getting employed? Would that be an unintended consequence of Obamacare?
You know, there's a couple of things that I see at work here. One is that if you don't want to sign up for this program, you're not going to want to work at CVS, right? So they're going to attract people who are okay with signing up for the program. The other interesting thing to me is that, you know, every company has a $63 charge now for every employee under Obamacare. So this comes out to about $600 a year. So if they decide, and I think a lot of companies are going to look for ways to sort of pass that cost on to the employee from Obamacare.
Now, one of the reasons this is so expensive is because Obamacare has a one-size-fits-all. So a human being who couldn't possibly use, let's say, abortion coverage is still paying for it in his or her insurance policy. You cannot tailor an insurance policy to your own particular needs. We knew that was coming, but I don't think we realized, even those of us who didn't read all 2,700 pages but have a good understanding of what's in there, I don't think we realized the economic effect of people not being able to get jobs because they're overweight. And maybe judges are going to have to decide what's obese.
What is overweight?
Is it 10 pounds heavier than your height? Is it 20 pounds? Is it 50 pounds?
Let's take a look at what CVS says about this, because they have this statement. All personal health data from these screenings are collected and reviewed by a third-party administrator. Rather, it is designed to help employees make the best decisions about their own health care. They also point out that 79%, according to CVS, 79% of companies have some kind of health assessment already in place for their employees. So they're saying we're not really out of step with what's going on in corporate America.
I think they're probably right. The reason we're talking about it is because it applies to such a huge number of people, 200,000 right off the bat, starting in a week.
And the fine clearly helps to pass along the cost of Obamacare to employees.
Absolutely.
Right?
Absolutely. Because, contrary to what the president said, these insurance policies will cost more than the coverage you had before the federal micromanagement.
Judge, always good to see you.
Pleasure,
Thank
Martha.
you very
Thanks for
much.
having me.
You know, I used to work at another network. The other place,
you
TOP.
did.
You had to sign a no smoking agreement. I don't think it was ever enforced, but I mean, the logic was that this was for insurance reasons. So maybe there's something there, Joe.
Yep.
9 minutes before the hour now, the drugstore chain CVS is now telling its employees to get a checkup or pay up. The new CVS policy calls for workers on its health plan to take part in a so-called voluntary wellness review that checks things including height, weight, body fat, and blood pressure. Workers who don't participate have to pay a fine, $600 a year. A CVS spokesman says the company's only looking out for the health of its employees. Experts say you can expect more employers to start doing this now. Joining us is Fox News senior judicial analyst Andrew Napolitano. Can they do that?
Yes, they can do it, because though they may say that they're looking out for the health of the employees, and there's certainly some health advantages to being aware of your height and weight and body fat mass and glucose level, they're also looking out for the health of their bank book, which they're entitled to do as an entity engaged in commercial activity. They know that it will cost them more to buy insurance policies for people who are more likely to use the services afforded under the policy. Now, they have known this for a long time, but now, under the Affordable Health Care Act, which begins to kick in a little less than a year from now, in January of 2014, they will be required to offer these policies as mandated by the federal government to everybody that works for them, even if the person is not capable of receiving a service afforded under the policy. So they have very little choice except to hire the healthy. Now, they're not saying that, but the consequence of this, Shep, is that people will have to choose. Do I want to pay the $600, $50 a month, and stay here, or I want to go somewhere else where they're not going to put this burden on me? And if I do leave, I'm likely to be replaced by somebody who doesn't have to pay the $60 a month because they fit within the range of height to weight.
Right. It begs the next level question, which is, will there come a time where if you smoke, if you drink to excess, if you eat a bunch of fatty foods, if you go to the candy machine, if you don't exercise, you pay more for insurance than those who don't do it?
You know, I have to guess on that, but I can see where this is going.
Could you do it?
Yes. Right now, with the CVS scenario, what is obese? Who's going to decide? Probably a federal judge. Is 5 pounds too heavy for your height? Obese. Is 30 pounds too heavy for your height? Obese. And how much smoking is too much smoking? How much alcohol is too much alcohol? Congress may jump in and make these determinations itself, but if it doesn't or it can't, then federal judges will be making this determination, an area where they really lack expertise. So the Affordable Health Care Act continues to have unintended consequences of a myriad.
I don't know if it was unintended.
Well, who knows if this was intended? This wasn't anticipated, that people would be fined if they cost their employer too much, and that the employer would have the right to do so.
The way to get health care costs down is for us to be better at taking care of our bodies.
Absolutely.
If you don't service your car properly, your warranty is null and void in many cases. Makes sense in a way.
Well, that's very interesting.
I don't like it, but it makes sense.
I don't know if that's going to come. If you don't have the proper relationship of height to weight, you're going to lose your coverage. I don't think that's going to come, but you're going to pay more for your coverage.
Yeah, makes sense.
Okay.
Thank you, Judge.
Pleasure, Shep.
The story we've been telling you about all morning, Italy's top appeals court has now overturned Amanda Knox's acquittal in her roommate's murder case, ordering a brand new trial. So, what is next for Amanda Knox? Fox News senior judicial analyst Judge Andrew Napolitano joins me now. Good morning.
Good morning, Gretchen.
All right, so let's get the first question out of the way. The United States does not have to force her to go back to Italy, right?
Correct. It's an extradition request. Even though we have this treaty with Italy, we don't have to honor it. We've taken this position if we believe that the proceedings in Italy will be unfair. It's not against Italy. It's the same position the American government takes with all countries. If the justice system treating an American in the other country would not treat the American with a level of fairness with which our system would treat the American here, we can refuse to send the person there.
Chances of her lawyers suggesting she go back, zero, right?
I think absolutely zero after what she went through. Her boyfriend, who was acquitted with her and whose acquittal was also overturned, has remained as a student in Italy. So he's in jeopardy. I don't think immediate jeopardy, because I don't think the Italian government would arrest at this stage. I mean, they still are, even under Italian law, innocent until proven guilty. It's like they're back at square one.
So would you predict that they will hold this trial and Amanda Knox will not show up, so she could be convicted or acquitted in absentia?
I think that's probably what will happen. If she's acquitted in absentia, the acquittal can be appealed again. In the EU, an acquittal can be appealed by the government. This is alien to us and absolutely prohibited by the Constitution in America, but the same laws do not apply in Europe.
All right, so today the United States probably won't extradite her. If she's convicted in absentia, will the United States extradite her to Italy?
You know, that's a policy decision that'll have to be made by whoever makes those decisions at the time, probably whoever is the Attorney General of the United States at the time the Italian authorities seek her. But again, the United States has a pattern of not automatically extraditing if American lawyers can persuade American authorities that the system is not consistent with American values.
All right, so you talk about other EU countries, though, European nations, that if she traveled to those nations, she might be in jeopardy.
Yes, she could be arrested this morning in any EU country and immediately delivered to authorities in Florence, Italy. Unlikely, even if she went there, that would happen, because, again, at this moment, even under Italian law, she's innocent until proven guilty.
So explain the difference in the appeals court system in Italy. Did they come up with new evidence to grant a new trial or want a new trial, or is this just public pressure? Because remember, she was painted in the media there as this monster, and many people were surprised that she was originally acquitted.
I'll tell you what the biggest difference is that's most frustrating to people that do what I do. The court didn't issue its reasons yet. It just issued the end result. In America, judges write opinions. Often the end result is the last few paragraphs, but it all comes out at once. In Italy, they just announced conviction overturned, new trial ordered, reasons coming. So we haven't read the reasons. But we do know a couple things. We know that this court is concerned with procedure, not substance. So this court must be articulating some procedural aberration by the courts below. We should find out later today or before the week is out what the reasons were for this.
And also, she has a brand new book coming out, and no one knows now how this will affect all of that.
She has been paid a lot of money for that book. It's coming out next month. One would think it's already written, already published, sitting in a warehouse ready to be distributed very, very soon.
Talking about starting over her life, and now she's back to the same place.
Square one.
Possibly.
Yes.
Judge Napolitano, thanks much for your expertise.
Pleasure.
Whether or not we get to the merits on this case, a decision from the justices will likely come in late June. Shep.
Shannon Bream, thanks. An institution that's newer than cell phones. An interesting take, right? Let's take it to the judge. Fox News senior judicial analyst Judge Andrew Napolitano is here. You could make the argument that this isn't new at all. I mean, it seems like the argument that the people who want Prop 8 out are making is, if this group of people in society are allowed to do something, whatever it is, through the state,
right,
then this group should be allowed to do it too, especially if in numbers they are the minority.
Well, you have articulated in your own unique way, Shep, the Equal Protection Clause in the Constitution, the federal Constitution, which says that the states must treat similarly situated people in a similar way. If it's going to grant rights to one group, it has to grant rights to a similarly situated group. That is the argument against Proposition 8. Just reading between the lines from Shannon's superb report, she was in the courtroom, I wasn't. I think that the court may very well say, we're not ready to rule on this. If that happens, then the Ninth Circuit Court of Appeals decision below stands, and Proposition 8 is invalidated, and same-sex marriage will be lawful in California, and those 18,000 couples who got married between the time the Supreme Court of California said it's lawful and the voters said it's unlawful will have valid marriages. And the reason for that is, as she articulated, the justices don't want to get into this issue of standing, basically saying to a lawyer, well, who are you? You don't represent the state of California.
And he doesn't.
How did you get here? You just can't walk in the courtroom and claim to speak in behalf of a movement. The governor doesn't want this law defended. We don't want to hear an argument about the law. And the same thing will happen tomorrow about DOMA, where
the Defense of Marriage Act.
Correct, where the President of the United States, whatever you think of his politics, has said DOMA's unconstitutional. I prohibit the Justice Department from defending it. So, pardon me, Chief Justice Roberts will probably say tomorrow to the lawyers defending the Defense of Marriage Act, who are you? What are you doing here? You don't represent the federal government. So these are two very unique procedural quirks that the court may very well say, we're not ready to hear either of these cases.
In that first scenario, I'm sorry, in that first scenario that you mentioned, Proposition 8 goes away. That affects California and California only.
Correct.
Then what we would expect to see in days, months, and years ahead is a series of lawsuits all over the country, specific and individual to each state.
Yes, that's correct.
And then at some point, as the tide turns, and the polls show more than 80% of people under the age of 25 don't understand why in the world you would care who else gets married as long as it doesn't involve you. I mean, come on. Then eventually the government would recognize that when they say equal protection, they meant equal protection for everybody. They meant equal protection for women. They meant equal protection for black people. They mean equal protection for gay people. They mean equal protection for all the people. And if the majority doesn't like it, that's too bad.
Well, that is an argument that, as you say, will have to be made in 49, because California will be done, in 49 different litigations in each of the remaining 49 states, rather than all at once before the Supreme Court once and for all.
Judge, we'll follow this. We should know something in June. More arguments tomorrow on the Defense of Marriage Act.
Yes.
Good to see you. Thank you.
Pleasure.
Right now, the Supreme Court is hearing more oral arguments on same-sex marriage. Today, the justices are looking at the constitutionality of the Federal Defense of Marriage Act and debating whether a legally married same-sex couple is entitled to the same benefits under federal law as a married man and woman. Today's arguments coming a day after the Supreme Court took up California's voter-approved ban on same-sex marriage. Let's talk about it with Judge Andrew Napolitano, a Fox News senior judicial analyst. Fascinating to me that you have the Obama administration arguing against a federal law that was just put on the books in 1996, scarcely a decade and a half ago, under Bill Clinton.
You know, it's very interesting, John, and it's really the first issue the court will look at. The president has taken an oath to uphold the law. All the laws, whether he agrees with them or not, but he has forbidden the Justice Department from defending this law. So there are lawyers interested in the outcome whose fees are being paid out of a discretionary fund that the House of Representatives has given to Speaker John Boehner. So don't be surprised if the first question that Chief Justice Roberts says to these lawyers is, who are you? What are you doing here? You don't have a client. The same thing could have happened yesterday, by the way, because Governor Jerry Brown has taken the same, of California, took the same position about Proposition 8 that President Obama has taken about DOMA. It's unconstitutional. We don't want to defend it. If you can get over that, if you can get over the fact that there's a lawyer here without a client and there's no lawyer really defending the statute, then the court will get to the merits. And the merits are, for tax purposes, can you treat a same-sex married couple differently than a heterosexual and married couple? In this case, it's a substantial tax bill. Married couple, both females, one dies, the other inherits the estate. Tax bill is $365,000. If they had been the opposite sex, the tax bill would have been zero.
They were married in Canada, though, under Canadian law. Does that make a difference here?
No, because they were living in New York at the time of her death. So her lawsuit against the IRS was filed here in New York City. And it is her victory in those lower court lawsuits of the trial court and in the Court of Appeals that is being appealed to the Supreme Court. If the Supreme Court were to say, we're not going to hear the appeal because there's no real lawyer here defending this statute, she gets that $365,000, but there is no national ruling on this. If the Supreme Court were to say, well, all right, this thing about no lawyer here, we got to resolve this one way or another, then whichever way it goes will obviously be the law of the land. The federal government either will have the ability to deny benefits to same-sex couples that it grants to opposite-sex couples, or it won't, and the court will decide.
The feeling among some people is that the court is going to somehow punt on this one, that it feels like setting concrete law into place right at this moment in history might not be the best idea.
That's a very appealing and attractive argument, and just judging from what the justices said yesterday, they are reluctant to be making these decisions. Now, the decision was made in 1996. The president who signed it repudiated it. That means nothing. It's still the law of the land. It doesn't mean anything. He could have changed his mind 2 seconds after he signed it. It's still the law of the land. The attitude of the public, however, has modified significantly since 1996. But this is still the law of the land. The Congress hasn't rescinded it. The president hasn't done anything to rescind it. He's just stopped enforcing it, though he didn't tell the IRS to turn that check over, which he could have done, but he didn't do that.
But does the government have an argument in maintaining, or does the government have an interest in maintaining traditional marriage between a man and a woman?
That's the question, because the government can't write a law for no reason. Every law has to have a rational basis. It has to have some reason. Any reason that makes sense. So the government would have to argue, here's the reason for the law. But the government's not in the courtroom. And in fact, President Obama dispatched government lawyers to argue against this law, which is truly unheard of in my experience.
So we could come out with a very surprising ruling, or
yes,
what's your prediction?
We could come out with a very unusual prediction. Oh, everybody says Justice Kennedy is the swing justice, and he seems to have a soft spot in his heart for same-sex couples. Who knows? He's going to do what he thinks the Constitution and the law requires, and it may not be the same outcome in this case as the outcome will be in the Proposition 8 case that was argued yesterday.
Could be a lot of, switching of jumping of the fences here in the Supreme Court.
Absolutely. They're supposed to do what the Constitution requires, not produce the end result that they want.
Judge Andrew Napolitano, thanks.
Pleasure, John.